in the matter of Hastings against Finsbury Orthopaedics Ltd. as another.
Lord Lloyd Jones will hand down the judgment in this appeal.
This appeal concerns a prosthetic hip called the Mitch Accolade product, which was manufactured by the respondents. The appellant, Mr. Hastings, underwent a total hip replacement using the Mitch Accolade product in 2009. He brought a claim for damages under the Consumer Protection Act, 1989, alleging that the product was defective. In the first instance, Mr. Hastings sought to establish that the Mitch Accolade product was defective in two ways. First, he claimed that there were certain flaws in its design. Secondly, he relied on three matters which were said to constitute prima facie evidence that the product was defective. These were expressions of professional concern by the orthopaedic community, the conduct of the respondents in withdrawing the Mitch Accolade product from the market, and finally certain notices and alerts issued by regulators and by the respondents regarding the product. The respondents relied upon expert evidence of biostatistics from Professor Platt. The parties agree that Professor Platt's evidence demonstrated that there was no reliable statistical basis for the claim that the revision rate of the Mitch Accolade product was out of line with the relevant benchmarks. The revision rate of a prosthesis is the percentage chance that revision surgery will be required to replace the prosthesis in a given period of time. In the outer house, the Lord Ordinary, Lord Tyre, held that the appellant had failed to prove that the Mitch Accolade product was defective for the purposes of the Consumer Protection Act. The inner house refused the appellant's reclaiming motion. Mr. Hastings now appeals to the Supreme Court. On appeal, he has not sought to pursue his case regarding the alleged design flaws. Instead, this appeal is concerned with the matters which Mr. Hastings submits are prima facie evidence that the Mitch Accolade product was defective. The central question which arises on this appeal is, therefore, whether the courts below were correct to find that, despite the prima facie evidence, the appellant has failed to prove that the Mitch Accolade product is defective. The Supreme Court unanimously considers that the courts below were correct to reach this conclusion. Mr. Hastings' appeal is therefore dismissed. This appeal was unusual because the legal issues concerning the application of the Consumer Protection Act are largely agreed. In brief, the Act introduced a system of no-fault liability for defective products. The test of whether a product is defective is whether the safety of the product is not such as persons generally are entitled to expect. The burden of proof is on the consumer to establish a defect and a causal link to the injury. Applying those principles to this case, the test of entitled expectation is whether the level of safety of the Mitch Accolade product would not be worse than existing alternative prostheses which would otherwise have been used. On appeal, the sole criterion relied upon to measure the Mitch Accolade product's level of safety was the revision rate. The burden of proof was on Mr. Hastings to show that the Mitch Accolade product's revision rate fell below the level of safety he was entitled to expect. The appellant failed to establish on a statistical basis that the Mitch Accolade's revision rates fell below the relevant benchmarks. The question which now arises is whether the appellant can rely on the three matters said to constitute prima facie evidence to prove his case. The Supreme Court considers that he cannot. I will refer in turn to each of the matters on which Mr. Hastings seeks to rely. First, the generalized expressions of professional concern do not assist Mr. Hastings in establishing that the Mitch Accolade product was defective because they related to the performance of metal-on-metal prostheses in general. Secondly, the withdrawal of the Mitch Accolade product from the market does not provide any support for the appellant's case that the product was defective, because the first instance judge found that the withdrawal was brought about by commercial considerations. Thirdly, the notices and alerts issued by regulators and by the respondents regarding the Mitch Accolade product do not assist Mr. Hastings. Professor Platt's evidence, which was unchallenged by the appellant, contradicts the information which formed the basis of the alerts and safety notices. The appellant submits that because there's limited available data on revisions in respect of the Mitch Accolade product, the true revision rate could be considerably different from the estimates based on the available data. However, the first instance judge rejected Mr. Hastings' arguments regarding the limited available data. The judge held that the appellant had failed to prove the existence of a defect. Ultimately, this appeal is no more than an attempt to appeal against the judge's findings of fact, which supported that conclusion. The appellant has failed to provide any basis for the Supreme Court to interfere with those findings. The appeal is therefore dismissed.
The court will now adjourn.